Good morning, good afternoon, and good evening, distinguished participants, dear colleagues from the World Bank and UNCITRAL. My name is Benjamin Harrison. I am a legal officer at UNCITRAL Secretariat, and I will be the moderator and the timekeeper today. Thank you for joining, and I see many judges still joining, the third session under the joint UNCITRAL World Bank Group Judicial Capacity Building Initiative on international best practices in the area of insolvency. This third session will focus on safeguards against improper commencement of insolvency proceedings and will feature a comparative overview of approaches to this topic, a case study, and an exchange of views as regards the solutions recommended in the 5 parts of the UNCITRAL Legislative Guide on Insolvency Law and the World Bank Principles for Effective Insolvency and Creditor Debtor Regimes. The session today will be held in English. As you know, you are able to listen to the session in Arabic, Russian, French, Spanish, and Chinese, thanks to the support of our partners, the Gulf Cooperation Council, the Eurasian Economic Commission, the Guangdong Association of Bankruptcy Administrators, the Groupe de réflexion sur l'insolvabilité et sa prévention, GRIP 21, and the Colombian Institute of Insolvency Law. I would like to express the gratitude of the Secretariat towards our partners for providing this important support to enable a diverse participation from judges from all over the world, as seen on the list of participants. Reference materials for the session today were circulated to you last week. All presentations are already on the event webpage. Speaker bios are included in the program for your information. This session today will last 3 hours with 1 break. I'm the timekeeper for today, and I will send reminders to speakers when the allocated time is up. Kindly note that no recording will take place except for the opening part, the first 30 minutes. You will be invited to turn on your camera for a group photo after the opening remark. And I will kindly ask you to keep yourself muted throughout.
Попрошу вас выключить
Silencio durante la
And to invite Miss
Sans
Anna
plus
Joubert,
tarder, j'ai le
Secretary of UNCITRAL, to deliver her opening remarks on behalf of UNCITRAL.
Honorable judges, dear partners, colleagues, and friends from the World Bank, dear colleagues, ladies and gentlemen, I'm very pleased to welcome you all to this third session of the joint UNCITRAL World Bank Group Judicial Capacity Building Initiative on international best practices in the area of insolvency law, hosted this year by UNCITRAL. From its official launch in 2021 until today, it brought together more than 700 judges from more than 65 jurisdictions. As you will see, the topic of each session of this initiative follows the sequencing of an insolvency case that may end up before you in court. The first session, held in 2021, focused on avoidance proceedings for transactions made before the opening of proceedings. In 2023, the second session looked at commencement standards, including measures to ensure timely, efficient, and cost-effective processing of applications for commencement of insolvency proceedings. Based on the feedback received from judges participating in the 2023 session, it was agreed that the session of this year would delve deeper into inappropriate uses of commencement standards, either by the debtor or by creditors, and tools available to judges to handle such cases. These tools may help judges determine whether a request for commencement constitutes a misuse of insolvency proceedings, and they would also provide judges with the capacity to deny an application for commencement or to dismiss insolvency proceedings already commenced. As you may already know, UNCITRAL's work in insolvency law has a long history, and it's well known in both domestic and cross-border contexts. Notwithstanding the impactful number of activities internationally featuring cross-border cooperation, initiatives for judges from different legal traditions to share their experience in dealing with domestic cases are still limited in number and in outreach. This capacity building initiative was designed precisely to fill that gap by providing a platform for judges, in particular from developing countries, to meet with fellow judges from other jurisdictions and
让
exchange
他们与其他司法 développement
and learn about
leur
а также ознакомиться с
Aprender acerca de las mejores
5 parts of the UNCITRAL Legislative Guide on Insolvency Law and the World Bank Group Principles for Effective Insolvency and Creditor-Debtor Regimes. Indeed, although the UNCITRAL Legislative Guide is primarily addressed to lawmakers, it also extensively discusses implications of legislative choices for the judiciary. It's therefore a great pleasure and satisfaction to see the great number of participants registered for this third session of the initiative, as well as the great diversity and variety in legal systems and geographical regions represented today. Let me also highlight the possibility to listen to the session in all official languages of the United Nations, thanks to our longtime partners from the insolvency world. We're extremely grateful for their implication, for their support, and for making this session truly multilingual. And I would be remiss if I did not cite here and thank the Gulf Cooperation Council for its support in Arabic language, the Eurasian Economic Commission for the translation and interpretation
наших
the
партнеров.
Guangdong Association of
Это
Bankruptcy
Совет сотрудничества стран Персидского залива, Евразийскую
Remerciements les plus sincères à nos deux juges principaux, le juge Nanili et le juge Radovic de Serbie, qui ont trouvé le temps, malgré leurs agendas judiciaires très chargés, de partager leur vaste expérience en matière de procédure d'insolvabilité et de rendre cette
y ley por la interpretación.
I could not end my welcoming remarks without expressing my special thanks to our two lead judges and friends, Judge Nalili Padmanathan from Malaysia and Judge Marko Radovic from Serbia, who found time in their busy court schedules to share their considerable experience in overseeing insolvency proceedings and make this session interactive and interesting. My colleagues from the insolvency team, our partners from the World Bank, the interpreters, and all registered judges of the course who are making this session a success, I would like to thank particularly. At the end of the event today, an evaluation questionnaire will be circulated to participants via a QR code and in the chat function. It's important for us to help us improve and help us focus the sessions that we design for you. Receiving your feedback is therefore really important, and it will help us prepare for future sessions. Let me again thank our co-organizers. Let me again welcome you warmly to this third edition of the initiative, and let me wish you all a productive and insightful session, and thank you for your attention.
Many thanks, Madame Joubin-Brett. And before I pass on the floor to Ms. Meneses, I would like just to mention that for interpretation, you have to choose on the bottom right of your screen, interpretation, where you click on that small planet, you will be able to choose the languages that you want to listen to. And now, welcome Ms. Antonia Meneses from the Finance, Competitiveness and Investment Global Practice at the World Bank Group to deliver her opening remark on behalf of the World Bank. Ms. Menezes, please.
Thanks, Benjamin. Honorable judges, colleagues from UNCITRAL, and invited guests, it gives me great pleasure to welcome you to the third UNCITRAL-World Bank Group Judicial Capacity Building Initiative focused on best practices in insolvency law. The World Bank Global Economic Prospects Report 2025 finds that the global economy is facing substantial headwinds and that for emerging markets and developing economies, this weaker outlook limits their ability to boost job creation and reduce poverty. We know that foreign direct investment is a critical tool to help mobilize private capital flows into these countries. However, we also know that investors and creditors need to know that if they make an investment, that they are able to recover in the event of that investment going bad. The World Bank Insolvency and Debt Resolution Program has collected empirical evidence, actual quantitative evidence, showing that stronger, more efficient insolvency systems impact the availability and pricing of credit, entrepreneurship levels, and job preservation in an economy. Having modern insolvency legislation and supporting institutions is therefore critical. This is where you, the judiciary, comes in. Having robust, technically strong judiciaries which are equipped to handle an increasing number of cases and modern complexities will be essential in supporting the functioning of your domestic insolvency regime. You are critical actors in ensuring both that creditor recovery is maximized and that debtors are not unduly sanctioned whilst protecting the rule of law and due process. It's for this reason that we welcome events such as this, facilitating judges sharing experiences from their domestic jurisdictions and developing ties with fellow judges in other jurisdictions. Together with the United Nations Commission on International Trade Law, the World Bank is designated as a joint standard setter by the Financial Stability Board. And it's with great enthusiasm that we jointly collaborate on this initiative with the aim of developing judicial understanding of our respective instruments, the UNCITRAL Legislative Guide on Insolvency Law, and the World Bank Principles for Effective Insolvency and Creditor Debtor Regimes, which are called the ICR Principles. Together, these texts form the unified standard for assessing the quality and strength of countries' insolvency regimes. The World Bank ICR principles were established in 1999 in the aftermath of the Asian financial crisis with the aim of helping policymakers build resilient financial sectors. In the 22 years since then, we have learned considerably about ICR systems and the role they play in promoting growth, access to credit, and the resolution of non-performing loans. Efficient, reliable, and transparent insolvency and creditor debtor regimes are invaluable in such contexts, but also in times of crisis when financial distress is present on a systemic scale. Our hope is that the ICR principles will aid policymakers, but also judges around the world in helping with the objective of creating more and better jobs in economies, assisting with economic development and growth, and better understanding best practice principles in restructuring and insolvency matters. On behalf of the World Bank, I would like to express our gratitude to our standard-setting partner, UNCITRAL, the primary and very impressive facilitators of this event who have really done such a huge amount of work to ensure that it is successful. Judge Nalini Patmanathan and Judge Radovich, the distinguished participating judges, yourselves who have found time in your busy schedules to attend, and all other invited guests. I wish you fruitful discussions and hope that you will find this a useful forum today. Thank you very much.
Thank you, Madam Secretary, and thank you, Ms. Menezes. Dear distinguished participants, I see we are around 170 people already here in the room, And I would like you to turn on your camera if it's not already done, and I see already many cameras turned on. And we will do a quick group photo, so please smile, wave your hands if you want, and say insolvency for 10 seconds so that our colleague and intern, Philip, can do the photo. And Philip, you'll raise your hand when it's done so that we can stop to do this gesture. Okay, great. So thank you, everyone, and back to work now. It is my great pleasure to introduce Ms. Samera Musayeva, Senior Legal Officer at the UNCITRAL Secretariat and Secretary of UNCITRAL Working Group 5 on Insolvency Law, and thereafter Ms. Nina Mocheva, Secno Financial Sector Specialist at the World Bank Group, who will give an introduction to the UNCITRAL and World Bank insolvency text, particularly those concerning the safeguards against the improper use of insolvency proceedings. Any question regarding the presentation can be put in the chat and will be addressed immediately after or later stage via email. Ms. Musayeva, please, you have the floor.
Thank you, Benjamin. Greetings, distinguished judges and colleagues. It's a pleasure to address you on behalf of the UNCITRAL Secretariat. This presentation focuses on the safeguards against the improper commencement of insolvency proceedings as elaborated in the UNCITRAL Legislative Guide on Insolvency Law. We will look at how the guide empowers courts to prevent misuse of insolvency mechanisms, both by debtors and creditors, and to ensure integrity, proportionality, and public confidence in the insolvency system. Philip, next slide, please. The commencement stage is one of the most critical points for system integrity. Once proceedings begin, the consequences are immediate. The insolvency estate is constituted, the control over the debtor's business and management is established, and proceedings against the debtor and its assets are stayed. At this point, the court's vigilance is needed. The UNCITRAL Legislative Guide on Insolvency Law recognizes this responsibility and provides courts with a framework to exercise their authority. Under the guide, courts may deny an application to commence insolvency proceedings or dismiss the insolvency proceedings after their commencement on the grounds specified in the insolvency law, including where the application is an improper use of the law. This authority is firmly grounded and exercised on the basis of the provisions of the guide discussed in the second session, such as definition of insolvency, jurisdiction, and eligibility criteria and commencement standards. The guide connects this issue also to valuation, to establish insolvency or solvency of the business, viability of the debtor's business, which in turn determines the type of proceedings to commence, liquidation or reorganization. The guide further invites the court to consider the sophistication and good faith of the applicant. Not every debtor or creditor acts with the same level of understanding. Some may be inexperienced, micro and small enterprises, while others are highly strategic actors. The guide distinguishes between the two. The guide also highlights links to other areas of law, for example, criminal law, where deliberate misrepresentation or fraudulent filings may require referral to other courts or imposition of additional sanctions. Finally, the guide emphasizes oversight, not only by courts, but also by all affected parties in interest, creditors, debtors, employees, and public authorities. Guarantees of their involvement at the outset, already at the stage of filing, aim to reinforce transparency and accountability. Next slide, please. Improper use of the law may take different forms. On debtor side, there could be filings made not to reorganize or liquidate in good faith, but to delay enforcement, abstract creditors, or to carry out what is sometimes referred to as Phoenix Act tactics, where the debtor seeks to shed liabilities and reappear through a new entity. On the creditor side, there could be petitions filed as a pressure or collection tactic, or to gain a competitive advantage by damaging reputation and placing a rival under insolvency when the debt itself is still bona fide disputed. They are all captured by the reference to an improper use of the law in the relevant recommendations of the guide for both standard and simplified insolvency regimes. Those recommendations are interconnected with other recommendations of the guide. Together, they provide safeguards to ensure that insolvency proceeding is not a substitute for adjudication of disputed claim, nor a shield against enforcement, nor to be used for other inappropriate tactics. Courts, as gatekeepers, have the discretion and duty to ensure that the insolvency process begins only when the insolvency law's true purposes are met. Next slide, please. How courts are expected to respond in practice under the guide when they suspect an improper commencement of insolvency proceedings. First, the guide presupposes that the applicant, whether debtor or creditor, acts honestly, with a genuine intent to seek collective resolution of financial distress. It's hence for the courts to screen the application for good faith. Second, courts are expected under the guide to assess solvency of the debtor, especially when the creditor applies for commencement of an insolvency proceeding against the debtor, or when the debtor applies for reorganization but viability of its business questioned. As we discussed during the second session of this initiative, such an assessment is recommended to be performed not only on the basis of balance sheets, but through a realistic view of the debtor financial position. Third, the court must protect the debtor from coercive filings by notifying the debtor of a credit application and giving it a chance to respond to it. This is expressly required under recommendations 19 and 297 of the guide. The court is also expected to protect other creditors and parties in interest, including by timely notifying them of the commencement of insolvency proceedings and by permitting them to object to the commencement. The guide envisages consequences if those protections are not fulfilled, including that claims of unnotified creditors may remain unaffected by insolvency proceedings. These protections are equally important not only for the debtor and creditors, but for courts, because inputs by other parties of interest may provide the court with a better and fuller picture and thus help courts identify improper applications. Fourth, where the filing constitutes an improper use of the insolvency regime, the court may deny the application or dismiss the already commenced insolvency proceeding. The need for dismissal arises, for example, when the insolvency proceeding automatically commences upon application of the debtor, which is the case in many jurisdictions, or when an improper filing is established after commencement, for example, upon the already mentioned notification of all parties in interest and their objection to the commencement. Fifth, the court may award costs to the aggrieved party. This serves as a compensatory and deterrent function, reminding parties that the insolvency process must not be weaponized. Finally, courts may impose other sanctions where warranted, for example, in cases of bad faith or repeated improper filings or misrepresentations. By doing so, courts are expected to ensure that misconduct has real consequences. Next slide, please. Why all of this important? First, because of the need for proportional and reasoned court responses. The guide reminds us that insolvency systems should be available to all, including micro and small debtors, and they should operate transparently and without intimidation. When the court responds firmly to bad faith, but constructively to honest error, it protects fairness while preserving access. Second, integrity at commencement is the foundation of public confidence in insolvency law, in the courts, and in the rule of law itself. Each commencement decision, whether to admit or dismiss a case, to sanction or to educate, sends a message to the marketplace that the process is one of justice, not strategy. The integrity at the starting point ensures that the entire proceeding is viewed as legitimate and impartial. And finally, Timely and appropriate court intervention prevents the needless expenditure of human, financial, and institutional resources. A careful review at the outset can prevent months of unnecessary litigation and significant costs to the system and its participants. These three values, fairness, integrity, and timeliness, are the anchors of the legislative guide. Together, they ensure that insolvency law remains a mechanism of collective resolution and economic renewal, not a tool of coercion or delay. Thank you for your attention. I wish everyone a productive session.
And now
Good morning.
Nina, yes.
I'm going ahead. Thank you, Benjamin. Good morning, good evening, and good afternoon, depending on your time zone. Greetings to our co-organizers from UNCITRAL, honorable judges, and all participants who tuned into the third session of our joint judicial capacity building initiative on international best practices in insolvency law. My name is Nina Mucheva. I am a senior financial sector specialist with the World Bank's Global Insolvency and Debt Resolution Program. I'll present a brief overview of the World Bank Group's role as a standard setter in the area of insolvency and restructuring, with a focus on our principles on improper commencement of insolvency proceedings, which is the topic of today. Next slide, please. So insolvency and debt resolution, as you heard from my colleague Antonia, have been an area of focus for the World Bank Group since the aftermath of the Asia financial crisis, when the Financial Stability Board designated the World Bank to lead the initiative to promote principles and guidelines for sound insolvency systems and for strengthening debtor-creditor rights in emerging markets. The international financial community considered that the implementation of internationally recognized standards and codes would provide a framework to strengthen domestic institutions such as courts, identify potential vulnerabilities, and also improve transparency. And together with our partner organizations, we have developed a set of principles which represent the international best practice in the design of efficient ICR regimes. Together with the UNCITRAL Legislative Guide on Insolvency Law, they comprise the unified standard for ICR, insolvency, and debtor-creditor rights systems, which is used to evaluate countries' regimes and institutions. Next slide. In addition to standard setting, very briefly, the World Bank Group's Global Insolvency and Debt Resolution Program also conducts comprehensive diagnostics called ICR ROSCs, reports on the observance of standards and codes, as well as diagnostics in the context of broader financial sector assessment programs, which we conduct jointly with the International Monetary Fund. We use our principles as a benchmark to conduct these diagnostics. We also assist our member countries through providing technical assistance in the revision of personal and commercial insolvency laws, the design of out-of-court workout systems, as well as capacity building for judges and insolvency professionals. Our team provides targeted assistance under budget support loans requiring regulatory reforms and support under specific loans on insolvency reforms in particular. And finally, we produce a number of knowledge management materials in the area of insolvency and debt resolution, such as manuals, toolkits, interactive trainings, and literature reviews on the impact of insolvency law reforms on the broader economy. Just very briefly, the World Bank principles are concised in four major categories. Principles A, which you can see on your right, cover creditor-debtor rights. They measure the secure transactions framework and the debt enforcement regime for secured and unsecured debt. Principles B cover the available tools for risk management and corporate workouts, including credit reporting and out-of-court workout practices. And Principle C cover various aspects of the legal framework for insolvency. Finally, Principles D measure the implementation of the legal regime through the institutional and regulatory framework. And several participants in an insolvency framework play a key role in achieving the goals of the regime. And these are the judicial authorities with jurisdiction over insolvency matters, the experts and trustees who perform various functions during the court proceedings, as well as the agency responsible for the selection and the supervision of the insolvency administrators appointed by the judges. Finally, I would add that the World Bank principles are a distillation of international best practice. They do not offer detailed prescriptions for national systems. The application of the principles at the country level will be influenced by domestic policy choices and by the comparative strengths or weaknesses of applicable laws, institutions, and regulations, as well as by capacity and resources in the judicial system and the entire insolvency system. Next slide. At the previous session of our initiative in 2023, we focused on the reasons why proper commencement of the proceedings is of critical importance for the overall functioning of the insolvency regime and the consequences that follow from the rules on commencement and their application. This time, we're continuing with another set of principles related to the accompanying safeguards against abuses and improper commencement, how the application of those safeguards are balanced against the requirements of time and cost efficiency and ease of access to the insolvency process, and finally, some special considerations for micro and small enterprise-specific insolvency regimes. The World Bank principles address commencement criteria in Principle 4, C4, and I'd like to point out your attention particularly to Principle C4.2.2, which stipulates that commencement criteria and presumptions about insolvency should be clearly defined in the law. The preferred test to commence an insolvency proceeding should be the debtor's inability to pay debts as they mature, the cash flow test, although insolvency may also exist where the debtor's liabilities exceed the value of its assets, or the balance sheet test, provided that the assets and liabilities, of course, are measured on the basis of fair market value. It's also important to note Principle C4.4, which stipulates that where the application for commencement of a proceeding is made by a creditor, the debtor should be entitled to prompt notice of the application, an opportunity to defend against the application, and to a prompt decision by the court on the commencement of the case or the dismissal of the creditor's application, which, as you will hear from the distinguished judges in the following session, is the most frequent consequence when they detect an improper rationale for commencement of insolvency proceedings instead of, for example, an individual debt enforcement action. This is very important to be detected by judges at this early stage because commencing insolvency proceedings that are collective by design can lead to very serious consequences for a debtor who is not in reality insolvent. Some key issues to consider in this regard are related to the possible ways in which the insolvency process can be abused, both by the debtor and the creditors. For example, this might include creditors seeking to impose illegitimate pressure on the debtor to pay a disputed debt by filing for the insolvency of a debtor instead of an individual enforcement action, or to influence the operations of or the management of the company. Judges should consider whether the domestic insolvency law provides for adequate safeguards against abuse that can be applied by the court, including sanctions and consequences of abuse. And finally, it is important to assess how to strike the right balance in preventing abuse while ensuring timely, efficient, and cost-effective processing of applications for commencement. Next slide. In this respect, let's look at some of the key issues for judges when deciding whether the insolvency application is genuine and has met the legally established commencement test, or, on the contrary, it is filed with an intention to unduly force an individual debt obligation when filed by a creditor, or to delay payment through taking advantage of the automatic moratorium on enforcement actions when filed by a debtor. And those are balancing an efficient access to the system against avoiding a premature finding of insolvency and liquidating a debtor's business when applying the cash flow commencement standard. In particular, judges from emerging markets may have to consider what additional analysis the courts conduct if the information in the company's financial statements is unreliable or incomplete, and how to establish the debtor's imminent insolvency or approaching insolvency or early stage of financial distress envisaged in the commencement standard for application by the debtor and the ultimate goal pursued in a particular case, whether it is preserving the business as a going concern or the piecemeal sale of its assets. It has to be acknowledged that there is a risk of parties commencing insolvency proceedings in a manner that is abusive or improper. By abusive or improper, we mean an application for commencement by creditors or debtors for reasons other than the intended use of the insolvency process. The reality of risk of abuse by the commencement of insolvency proceedings raises several issues, including the role of the judge in safeguarding against abuse. The part of the World Bank principles related to this issue is Principle D63, Integrity of Participants, which stipulates that persons involved in a proceeding must be subject to rules and court orders designed to prevent fraud, other illegal activity, and abuse of the insolvency and creditor rights system. In addition, the court must be vested with appropriate powers to enforce its orders and address matters of improper or illegal activity by parties or persons appearing before the court with respect to court proceedings. And during the following session, we will hear from our lead judges how this is handled in insolvency proceedings in their jurisdictions. Next slide. The World Bank principles provide for an overall guidance on measures that can help ensure timely, efficient, and cost-effective processing of applications for commencement. Principle C41 indicates that generally that access to the insolvency system should be efficient and cost-effective. One way to achieve this is listed in Principle C42, which I touched upon previously, and that's for the commencement criteria and insolvency presumptions to be clearly defined in the law. Furthermore, the World Bank principles provide more guidance as to how simplified insolvency proceedings designed to cater for micro and small enterprises can achieve even greater speed, efficiency, and cost effectiveness. This includes reduced procedural formalities, easy access to proceedings at an early stage of financial difficulty with a rebuttable presumption of insolvency, or financial difficulty which is created by a debtor's filing, showing proof of basic criteria, Principle C19.2, and broad and clear eligibility criteria. The key issues that we would like to draw your attention to here are the role of the legislative framework in encouraging the timely, efficient, and cost-effective processing of applications for commencement, and specific approaches taken to commencement of insolvency proceedings in micro and small enterprise specific legislative frameworks, which Principle C18 complements with the prescription that MSC-tailored procedures should include an effective regime to prevent and sanction fraud, improper use, and abuse of MSE insolvency proceedings. MSE stands for micro and small enterprises. This is important, particularly because MSE procedures typically have less stringent requirements for commencement, and the burden of proof is reversed from the ordinary or the default proceedings and falls on the creditor when the filing is done by an MSE debtor. With that, I would conclude my remarks on the World Bank principles on this topic, and I would like to hand it over back to Benjamin. Thank you.
Thank you, Ms. Musayeva and Ms. Mocheva. Dear distinguished participants, the PowerPoint slides are available on the event webpage, and the link is found in the chat.